But you don't, right as we sit here now, you don't have a plan to how you're gonna be able to do it.
With my mom passing, my life fell apart. I have no idea that she was really all I had. So
And you just haven't gotten in touch at all with Hawk.
the call that I had with them, that was it. They was like, maybe if you can at least pay 800 and
When
you
was
know,
that?
that was like last week. Landlord, and that she had mentioned that to try again because I tried with Hawk before. She said try again. So that's what I
Did
did.
you try again or?
I had called, yeah, I called them.
Oh, that was the try again.
Yeah, that was.
You got to have a plan in place. Right now, you don't. And what worries me is you're not sure what you're doing next,
I have no.
right?
Correct.
Okay, so Gulfside Lake 3 versus Latanya Powell.
James Fink for the plaintiff.
Oh, there she is. Hello.
Hello,
What's your name?
Latanya P. Powell.
All right. Where are we on this case? This is your motion.
I'm looking to see if this was a motion or a no writ without a hearing case.
I think it's a motion. I'm sure it's a motion.
I don't know that I have a motion, but she paid $538 after entry of the judgment. She's paid nothing since.
All right, what do you want to tell me? She had indicated her mother passed away. She was taking care of her mom, and then, well, why don't you tell me?
Yeah, my life just pretty much fell apart from there. I'm just started as well. I just got a job working for the post office, but I'm in training right now, so I just wanted to let you know that I was sort of working like cleaning houses, but that's not enough to pay my bills, but this job will be.
So, all right. What's her balance at this point? Because February
382109 382109.
Have you gone to apply for assistance at all?
I asked Hawk and they said they could potentially help me if I at least pay like 800. But I feel like, they mentioned that to me before in the past and I brought it down like they told me and they did not help me. So
When was that though?
that was like last year.
Okay. So, and I mean, some of that may have been where they told you that they didn't, and then all of a sudden their funding went away. So it's not that they wouldn't do it, it's just they didn't have the funds there. When do you get paid from this job now? I mean,
With me being in training, I couldn't even tell you. Like, so yeah.
Can you move out this weekend?
If I was to do that, I was thinking next week, maybe. Oh, can I also just be transparent with you? I know my bill is looking kind of crazy and everything that I got going on. I'm also a little nervous to like accept time as well because, let's say you give me a certain amount of time and I'm still not caught up. I just would prefer to avoid eviction. Like if I have to move out, I'll gladly do that. I could be out next week, but I just really need to avoid the eviction if possible.
if you're out next week, where would you go?
That's another story. That I don't know, but that can be figured out. What I can't figure out is having eviction on my record for 7 years.
But you don't, right as we sit here now, you don't have a plan to how you're gonna be able to do it.
With my mom passing, my life fell apart. I have no idea that she was really all I had, so.
And you just haven't gotten in touch at all with Hawk.
The call that I had with them, that was it. They was like, if you can at least pay 800 and,
When
you
was
know,
that?
like, that was like last week. I had talked to the landlord and, that she had mentioned that to try again, because I tried with Hawk before. She said, try again. So that's what I
Did
did.
you try again or?
I had called, yeah, I called them.
Oh, that was the try again.
Yes, that was, yeah.
All right.
Is Miss Amy online?
She is. And so here's what I'm gonna do, ma'am. You gotta have a plan in place. Right now, you don't. And what worries me is you're not sure what you're doing next,
I have, no,
right?
correct.
So here's what I'm gonna do. I'm gonna adjourn it. I'm gonna give you one more week to try to see what we can get through. So the 27th, 2026 at 2 p.m. That's an in-person hearing. But what I want you to do right now, I want you to go down to the clerk's office. Can you let them know that you're gonna go into one of our rooms, get on a computer there. They'll sign you into my meeting here. And then I'm gonna put you into a breakout room with Amy, the court liaison officer, and see what resources and other things are out there for you.
Okay.
Okay?
Yep. Yep.
Do you have proof that you're employed by the post office?
Yes, I mean, I have my badge, that works.
Oh, okay. So, okay. I'm just saying they may, one of the things is going to be, are you going to be able to sustain, if you stay there, are you going to be able to sustain living there? And
As far as like, for example, like if let's say I'm working towards knocking down my balance. For me, when I'm in like actually really start the after my training days are over, I will be in the post office. I know from there I can be back ahead, but
no, I got you. I understand what you're saying.
I just don't know as far as the plan of how to get caught up.
Right. I know. That's why we're going to try to figure that out. Okay. So go down there. They'll be waiting for you. They'll put you on a computer. We'll put you into a breakout room with Amy.
Okay.
And then we'll see you next week at 2.
Okay. Thank you so much.
You're welcome. Hamilton Crossing 2 versus Veronica Whitsett.
James Fink for the plaintiff.
Hello, Miss Whitsett. How are you? I think I'm doing okay. We'll see. All right. You filed a motion. So that explains your good cause. But then
That motion either.
right, yeah. We have an issue up front about mailing these out, getting them out.
Well, until Miss Q Powell gets on the job, the post office won't get it there on time anyway.
Right. Basically, she's indicating she was at work. She works with people who are ill. She didn't have anybody to relieve her with the client that she was with. All right. So how much does she owe at this point?
$23.75. She owes $17.45 on the judgment. She posted, I think, $6.60
today,
today.
which brought up to 2 months rent of $11.60. So that would be, I think, 12 something. So my dilemma was, I was basically living beyond my means and my finances got stretched. They cut our overtime at work. I don't know what's going on there. But they're basically overworking us, but not wanting to give us the overtime. And it put me in a bind. So now, like everything is behind. I called Hawk and they told me that I made too much money, but I have my son living with me. But they said they had to talk to him and he's in Philadelphia with his father. So they told me without him, I couldn't even make an appointment. So
That's an adult son.
the adult son, he's 25. And so when I went to my doctor's office, like I'm feeling stressed at this point. So the liaison at my doctor's office is trying to help me. But again, that's all I got as of right now. And like everything is super behind. And so I wouldn't be able to rectify it and pay it until the 7th.
Get that all right. All right, Mr. Fink. Good afternoon. Would you like to take a default?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Your Honor, this is an action for non-payment of rent. This defendant, Kevin Sherman, is in arrears $1,289.52 in rent. The taxable costs are $172. We request a default judgment in the amount of $1,461.52 with a writ to issue after the statutory period. This is a possession-only judgment, Your Honor.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you.
And you know what I think? I think there's a sticker for this file went the same place as my staff. Because there is none.
You mean right here, Your Honor?
Just saying. All right. Court calls the case of Gulf Site Lake 1 and 2 versus BK, is it the area?
James Fink for the plaintiff.
How you doing?
I'm doing well. Your name?
Bakai Diarra.
All right. And what are we doing?
Well, he owes $2,941.17. He applied at DHS today, but not within, well, it's today 5 days.
He's fast. Yeah. Well, hold on a second. Did you pay them $1,000 today?
No, I didn't get to pay the $1,000. I'm supposed to get paid today for my job, so I was going to combine that and maybe get that in by the end of the day or tomorrow.
Okay.
Yeah, but I did call Hawk, like how you told me, and they sent me to the ozone, and they sent me a list of numbers to contact, and I applied through DHS to get the assistance, and now it's just pending.
Did Hawk give you an appointment?
No, I didn't. I don't know.
When did you call them?
This morning,
Why'd you wait so long? I mean,
because I've been trying to catch up on certain bills, and I haven't even been at home like that. So, yeah, I just been trying to catch up on a lot of different things.
Your Honor, we're 5 weeks from the issuance of the summons.
I know. Sir, I'm going to issue a judgment finding no tribal issue after a hearing for the total amount of $29,41.17. And the writ would issue normally on the 2nd. I will have it issued that Friday, the 6th. So I'll give you a little bit of extra time, but you got to get it together. And this doesn't include what you're going to.
I'm just super behind, especially, having to pay a car out of the impound and,
No, I
it's been
get
a lot
it.
of stuff,
I get it, but it's
Yeah.
gonna get even worse if you don't have a roof over your head.
That's totally true.
All right. Thank you.
I understand. Thank you.
In your honor, I'll just say, we looked at the ledger together. Up until this case, he'd been there 18 months and had never had a case filed on him,
On here.
which is, as the court knows, not something that everybody's able to achieve.
Right.
I hope you make it.
Yeah, thank you.
All right.
Appreciate it.
Thank you.
All right, you enjoy your day.
Oh, no.
May we approach, your honor?
Who? You, Miss Wesley? Yeah, come on. Lincoln on up in here.
Work. So my check tomorrow isn't gonna be that much and I still have to get to work. And I have bills that come out of my check. My car note and everything comes automatically debited. So once they take that in my insurance, I'm not gonna have it tomorrow. Or Monday. Whenever they pay us, they've been sporadically paying us. Sometimes I get paid on Saturday and sometimes I get paid on.
But you can say that you're gonna tell me that you can pay up everything.
By the 7th of March.
Let's make sure we're all talking about the same number, your honor.
Okay, go ahead.
So that'll be about 3,000. And how much do you have in escrow?
How would,
$660.
how would it be
Hang on.
$660.
11?
That's all you have? You don't have anything else?
Well, hold on a second. Did you make 2 payments to escrow?
I made one today and I.
That's why. Okay. I was looking at that receipt and not looking at the register of action. So I actually have 1160
Yes.
in escrow. Is that right?
Yes.
Okay.
So she'll owe 2, a little less than 2 in March.
How?
Well, because March rent gets added.
To the 1735, right?
Well, right now you owe 2375.
That's with March's rent, sweetie.
No,
It's not.
no, that's February's rent.
Because your judgment was in January.
I'm confused. I'm confused now. So
Okay, your judgment, when it was taken,
I'm
it was
sorry.
taken on January 30th. So it was taken right at the end of January.
Right.
So since that time, your February rent has clicked in.
Which made it 17. I thought
How much is your monthly?
my rent is 580.
The judgment was 1745.
Correct.
And I had made them a payment. I really only owed
580 plus a late fee has been added for February, so that's 630. So that took it to 2375. And add another 580 on March 1st. Late fee won't kick in until the 6th, so that'll be 28, 29.55.
5 is what I get. And so at 29.55, then if I count 1160, can you give me that? 29.55 minus 1160. 17.95
Oh,
or thereabouts.
but I guess I gotta work on it. I don't have a choice.
Hmm?
I don't have a choice. I'm way total off. I'm gonna have to get my ledger from them because it's not. And to me,
So you're, oh, what I was gonna do is this, I was gonna release all of the escrow to the plaintiff.
Mhm.
I was gonna sign the order of eviction, but indicate that it cannot be executed till, do you get paid that Saturday?
yes,
Okay, so that it can't be executed until March 9th.
okay,
Oh, so I'm signing the writ though. So if it's not paid, that she's got to pay March, part of this also is that she's got to pay March. She's got to have a zero balance. You got me?
yes.
And I'm going to extend your time, but I'm not going to recall the writ. I'm not staying it. It's going to be out there, but understand if it's not paid on the 9th, they can show right up. They
Gotcha,
can go all the way up with the preparation of doing it.
gotcha,
You understand me?
yes.
Is that Mr. Moore?
Yes, it
I want to
is.
make sure that he understands not to,
Yes, we will make sure.
thank
And
you.
it's you said 1735? That's what,
1785, but check with the
1785.
office, because by the 9th, it'll be another 50.
okay,
You can have that.
oh, thank you. All righty,
You know what you need to do? Go find some money.
yeah,
Okay.
definitely, for sure.
Thank you, Your Honor.
Thank you. Well, man. This writ needs to be prepped. And then just put on there, yeah, you can put it on there. Not to execute it for the night, but also send an email to more. All right, thank you.
Thank you.
Gulfside Lakes 3 versus Harley Argo, that matter's dismissed on plaintiff's motion without prejudice. Thank you. Who is? Miss Argo?
Yeah, I'm here.
Okay, they dismissed your case.
I
Is
know.
that all?
Yeah, I just wanted to hear you say it again.
Okay. All right.
All right. Thank you so much, Judge. You have a good weekend.
You do the same.
Thank you. Bye-bye.
Real Properties versus Cozine Welch.
Lexi for Bill Properties, Your Honor.
They're not here. You want to take a default?
I definitely do.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. At this time, we would be requesting a default judgment for possession only where the outstanding rent to retain is $3,265, court cost of $175, total outstanding balance is $3,440. We're asking for a pay or vacate date of March 2nd, 2026.
Judgment to the plaintiff. That's by default for possession. Redemption of any amount requested within 10 days.
Thank you, Your Honor.
Woodview Commons versus Whitney Albright.
April Lake Woodview Commons, Your Honor.
Hello. What's your name?
Whitney Albright.
All right. What are we doing?
Thank you, Your Honor. I did get a chance to speak to Ms. Albright, and she's indicated to me that she'll be able to have everything paid before the end of the month. So we entered into a consent judgment, giving her until March 2nd to have the balance paid in full, which is currently $8,311.42 in past due rent, $175 in court costs, a total of $8,486.42. I did advise her of her rights under MCR 4.201 subsection J.
I was just gonna wait for Lacey to finish before I start talking, because see if I start
Said you
talking.
were gonna do that. You were gonna,
Well, I was gonna do what?
nothing.
Was she talking? Was she talking about me?
No, never.
Yeah, was she? See, this is what I'm talking about. It's how people get in trouble. Ma'am, you're gonna be able to get that all paid by then?
I am, yeah. Yep. I actually have taxes. They're coming back in and I showed her too the proof of it. It was all accepted. And luckily I paid a lot in, so I'm getting a decent amount back. So we're gonna be all set.
I
Hopefully.
wish that worked that way for me. I just keep.
Right?
I don't know.
Actually, I have to thank my tax person last year because I paid so much in. She's like, we're gonna take a bunch out this time and set you up. So
That way. Okay, gotcha.
Yeah.
All right. Then I will enter. Give me a judgment. Yes. All right. So you had no questions regarding any of this. Is that correct?
correct.
All right. Well, under the judgment by consent, you've been apprised of your 3-day rescission rights. All right. Very good.
Thank you.
Thank
Your
you.
Honor.
Have a good weekend. Thank you, Miss Lacy, for not saying anything real bad about me. Yeah, I'm sure. All right, you too. 14A.
Is approaching. Miss Hunter, when you arrive, could you state your name for the record, please?
Lucretia Hunter.
Hold it. Were you here? You're in this block too?
Yeah, Judge. I can stick around all day, if you know.
Why are you threatening?
Your Honor, on this matter, we've very recently retained. We have received the police report, but we're awaiting further discovery of the adjourn date for PCC.
Probable cause conference, March. Hey, remind me, what did I set your other ones?
I believe
The 12th or 19th?
we have one on the 12th.
12th. March 12th, 2026, 9 a.m.
And Your
I
Honor.
don't know why I'm being so courteous today.
I appreciate it though,
No,
Judge.
but it's
You know,
really throwing me off. I feel that way.
well, continuing that, Your Honor, to ask Your
Now
Honor,
you're gonna mess it up.
I probably am. Your Honor, I'm
You
gonna
are?
bring up just
You're gonna mess it all up?
one part of bond today, Your Honor. That is that Miss Hunter is currently wearing a tether. It's a GPS tether.
Mhm.
She's got a 16-year-old at home. She's a single mother. She's 37 years old with no prior record of any kind.
Free to put the tether on the child?
What's that?
Nothing.
You never want to offer that to
Yeah,
a parent of a
it's a
teenager,
teenage.
Judge.
Yeah.
But you know, it's interfering with a lot of parts of her life. She has not violated in any way since that thing was imposed. She has no interest in seeing the alleged victim of this case, and doesn't really have some pre-existing relationship with this person.
Bruce Bronson, people.
Your Honor, we'd ask each other to remain. I do know something from the Hots where there was an egg assault conviction. But
For
this is an incident.
an egg assault on,
By this, the defendant has a conviction from 2008 or 9. So it's older. The reason I would request her to stay is this appears to be an incident that also involved various former and current relationships and overlays with all of that. So I think that keeping them apart and knowing, giving the victim peace of mind is important. We have a chance to contact the victim.
Yeah,
Contact the victim regarding that.
On information and belief, an ag assault was thrown out in the aughts. So I don't know if
No,
that's challenged anyway.
That's fine,
But-
it's 8, that's, I was like 12 when that.
And so Your Honor, and these connections are alleged to be with the defendant's sister, not the defendant. So she really has no overlap unless you go through family and other things. She knows where the line is.
Who is this person
This is
in
a
relation
person,
to, the alleged victim is whom to this defendant?
so the alleged victim's baby's father was allegedly sleeping with the defendant's sister, which caused the alleged victim to go to the residence of the defendant's sister, and this incident
And she
arises,
happened to be there,
and,
and she's at her.
but we don't want to,
The defendant may have been at her sister's place, then this person comes there.
yes, that's on information and belief, Your Honor, that's all correct. There's no allegation of seeking out.
Other than that,
That's it,
is
Judge.
there any other connection that this individual would have with this person?
None whatsoever.
And she's got a GPS teller. So it's not even it's not even one that has an exclusion on it. It's just a GPS tracking where she's going.
I believe that's correct. There is a no-go-to here.
Right, there's a no-go-to, but I mean,
I don't want to speak out of turn, Your Honor. I do not.
no, I got you, and I realize you just got into this.
Some GPS tellers have what's called an exclusion zone.
Judge, my notes from the arraignment show an exclusion, GPS teller with an exclusion.
Yeah, no.
I'm going to continue the defendant's bond, however, I'm going to remove the GPS teller. I don't, if circumstances such as that, I don't see it a need for.
Thank you so much, Your Honor.
You'll, I'm sure, inform your client, don't give me reason to put it back on or incarcerate it, right?
Very clearly, Your Honor.
Huh?
Thanks again.
Yeah, well, yeah, so that there's an order to go over there.
Take care, Your Honor.
Thank you.
Thank you.
Court calls case People versus Edward Gross.
Morning, Your Honor. Raymond Cook, Peaceful.
Assistant Public Defender Jay Bellinger on behalf of Mr. Gross, who approaches Your Honor. Can you please state your name for the record?
Edward Gross. How are you, sir? Hi. Are you a Chiefs fan?
And
I
wasn't born
Show
and
'em-
raised.
show 'em what you got
under
It
that.
depends on if you are.
I'm not.
I'm not either.
Show them what you have. Show them what you have on under that.
But I got this just in case.
Oh, okay, all right, well, okay, that'll work.
Your Honor, we are here for a plea today.
All right, I have a form that indicates he's going to plead to an added count 2 of retail fraud second, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor. That is our understanding as well, Your Honor. And is that your understanding, Mr. Clerk?
Yes, yes,
May I
sir.
have him sworn?
Raise your right hand.
Other right hand.
Sorry, man. That's it.
He's a Chiefs fan.
Yeah.
Anyway, go ahead.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
State your name.
Edward Gross.
Sir, it is the court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 2nd degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not-
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
I am a Chiefs fan, but that doesn't count. No, Your Honor. No,
Anybody threatened you or coerced you? into
no,
anything?
Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Oh, yes, Your Honor. Sorry.
October 8th, 2025, at the location of 3825 Carpenter Road, Pittsfield Township, Washington County, State of Michigan. What'd you do at the Meyer store that makes you think that you're guilty?
Your Honor, may I?
Yes, please.
You were at the Meyer store on that date and time?
Sure.
And while inside the store, did you take or move sports trading cards and grocery items that belonged to the Meyer?
Yes.
And at the time you did that, you had not paid for the merchandise, is that correct? And when you took or moved the merchandise, did you intend to take it without paying for it? And you understood that the merchandise belonged to the store and not to you, correct?
Yes.
And the value of that merchandise was more than $200, but less than $1,000?
Yes.
And that store was open to the general public?
Yes.
Satisfied, Your Honor?
And you didn't have anybody's permission to take that property, did you, sir?
No, Your Honor.
Sir, I do have to advise you, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that the court would not be bound by any sentence evaluation or recommendation, and you could not withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation.
That's here.
Sentencing in this matter will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. That's before me. Bond will continue. Thank you. Sir, on your way out, my probation department is on the left-hand side down the hallway. You need to stop in there before you leave the building.
Okay.
Understood?
Yes, Your Honor.
And yep.
And then,
Court calls the case, People versus Robert Harris.
This is Public Defender Jay Bellinger on behalf of Mr. Harris, Your Honor, who should be in appearance via Zoom.
Harris? Nope.
Harris? Your Honor, I would request, we were in contact with Mr. Harris, Your Honor. I have had contact within the last few days with him. I'm surprised. I'm just as surprised as the court is, I assume, that he's not here today. So
I'm not shocked.
Oh,
No, I'm kidding. No.
so I mean, I would ask for an adjournment on this. We have had contact. He is still working towards a misdemeanor on this case, Your Honor.
Bench warrant will issue for defendant's failure.
Come on.
Fine, 10,000. Cash surety. That warrant will issue immediately.
Immediately?
Yes.
What about like in 2 days from now?
No.
Give me 48 hours.
It's gonna issue as soon as that file gets down here and you keep talking, I'll get a clerk down here to enter it now.
Thank you.
You're welcome. Court calls the case, People versus Kenneth Herndon.
And is that we have the people here? And Maggie on behalf of Mr. Herndon, who's approaching.
Kenneth Herndon.
Thank you, sir.
Yes, sir.
I would like to set this matter for exam and all discoveries complete as far as we're aware.
That's how she's been doing all day.
Mr. Brown taught me well.
Is that what he taught you? To do this?
Yes.
No, that's not what he would do. People have their witnesses available on the 3rd. Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Was the court, that was a progress report? From.
Yes, I am. Do you have a medical?
Yes, sir.
He has a medical marijuana card that, well, do you currently have do you have a new one?
No, I still have one it's.
And Your Honor, I think it says it expires.
Oh, it expires later this year.
Yes, sir.
Okay. So,
He, if I may, he got into a car accident that day and he called his probation officer right after that occurred and he tested on the next available day when it was open.
And I'm ordered to go today as well.
does state he was, yeah, he missed a sample, but it says he was in a car accident. You said you tested. I just don't have an update.
Yes, sir. I tested and I'm tested today as well.
Pardon?
I'm supposed to test today as well. And I tested after that day.
Oh.
Nope.
It's fine. He's
Thank
good.
you.
Thank you.
Thank you,
But
sir.
you wanted to take him. You did?
Getting ready. He was.
What? I know, he's getting ready. He's always, Alan is always ready. Uh-oh, you good? What, you want me to take, you want to go with Mr. Allen? All right, then go. He didn't quite know what to do. Court calls the case, People versus Dustin Hufford.
And back on behalf of Mr. Hubbard, who is a public defender. Please state your name.
Dustin Hufford.
Thank you.
And at this time, we are waiving preliminary exam.
Sir, you're waiving your right to a preliminary examination? Yes?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes?
Yes, sir.
All right. And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
There is an offer expected, that Mr. Hopper can avail himself of the circuit court, which would be a plea to count 2 and a dismissal of count 1.
Got it. Preliminary examination having been waived, defendants bound over to circuit court on both counts. Okay.
We acknowledge receipt of information waived formal reading. My client will stand mute.
Where'd you go? You just. Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for
April 9th at 1:30 with Judge Slay.
April 9th, 2026, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bound will continue.
The defendant waives the preliminary examination, meaning the case moves forward without the prosecution having to present evidence at that stage. The court formally binds the defendant over to circuit court on both counts. Defense counsel acknowledges receipt of the information, and the defendant stands mute at arraignment, prompting the court to enter a not guilty plea on both charges. With that, the next step is set. A pretrial hearing scheduled for April 9th, 2026 at 1:30 p.m. before Judge Slay. Bond remains in place as the case advances to the next phase. Now the real question begins, when a defendant waives prelim and stands mute, is it strategy or just buying time before trial? Like and share if every courtroom move matters.